Welcome to the next lecture of American Government 2. I'm your host, Dr. Michael Baggs, and our topic this week is civil liberties. Civil liberties and the Constitution. Civil liberties are protections from improper government action. They are legal restraints that are imposed upon the government. Some of these restraints are substantive liberties, which puts limits on what the government shall and shall not have the power to do. Other restraints are procedural liberties, which deal with how the government is supposed to act. Civil liberties require a delicate balance between governmental power and governmental restraint. The government must be kept in check with severe limits on its powers. But at the same time, the government must be given enough power to defend liberty and its benefits from those who seek to deprive others of them. Civil liberties are an excellent example of the tension or coexistence of majority rule and minority rights. Even though the Bill of Rights was added to the Constitution to ensure its ratification, this did not settle the question of civil rights once and for all. Consider what life was like in the 1950s. African Americans could not vote in the South. Criminal suspects in state cases did not have a right to be informed of their rights. Women were routinely and openly paid less than men for doing the same job. Civil liberties, a brief history. The Constitutional Convention concluded without a Bill of Rights in the document. The Federalists, led by Alexander Hamilton, argued that a Bill of Rights was unnecessary. The Bill of Rights would be relevant to a national government that was given only specific powers in the first place. For why declare that things shall not be done which there is no power to do? Hamilton argued that the Constitution, as originally written, amounted to a Bill of Rights by itself. Rights in the original Constitution. The Constitution contains habeas corpus rights. It is Latin for you have the body, and it is court order directing any official holding a person in custody to produce the prisoner in court and explain why the prisoner is being held. It is a remedy for any illegal confinement. The Constitution contains a prohibition against bills of attainder, which are legislative act that sentences a person or group to punishment without a trial. There is also a prohibition against ex post facto laws. These are any laws that define something as a crime after it was committed, increases the punishment for a crime after it was committed, or reduces the proof necessary to convict someone of a crime after it was committed. There's a guarantee of a trial by jury in all crimes in the Constitution. The Constitution also defines treason, notes the proof necessary for conviction, limits the punishment for treason to the accused only, and protection against using the crime of treason to restrict other activities. Anti Federalists argued that the Constitution would have to include a Bill of Rights with a provision preserving state rights. The Bill of Rights. The Anti Federalists successfully argued that the lack of a Bill of Rights was a major imperfection. The Federalists agreed to add a Bill of Rights to get the ratification done. The U.S. House adopted 17 amendments, and the Senate adopted 12 of those amendments. Only 10 of the amendments were ultimately ratified by the states. These 10 amendments are called the Bill of Rights. These rights represent important civil liberties. These are personal freedoms that are constitutionally protected from government interference. Nationalizing the Bill of Rights. The First Amendment is the only amendment with language specifically limiting the national government. Congress shall make no law. Therefore, some people question whether the Bill of Rights sets limits on only the national government or whether it also limits the states. Initially, the Supreme Court in Barron v. Baltimore in 1833 interpreted the Bill of Rights to limit only the national government. It was not until the 14th Amendment was adopted in 1868 that there became a way for the limits on the government action found in the Bill of Rights to be applied to the states. However, the Supreme Court did not apply this interpretation for nearly 100 years. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The Supreme Court in 1897 ruled that the Due Process Clause of the 14th Amendment applied to the states. It prohibited the states from taking property for public use without just compensation. In Gitlow versus New York in 1925, the court decided that when fundamental liberties are at stake, the Due Process Clause of the 14th Amendment prohibits the states from infringing on those liberties. The case concerned freedom of speech, and the court ruled that freedom of speech is among the fundamental personal rights and liberties protected by the Due Process Clause. The Supreme Court further expanded fundamental personal rights and liberties to include freedom of the press in 1931 and freedom of assembly in 1939. The most significant case, Palco versus Connecticut 1937, established selective incorporation. This is the process by which different protections in the Bill of Rights were considered one by one and selectively applied as limits on the states through the 14th Amendment. Until 1961, only the First Amendment and one clause of the Fifth Amendment had been incorporated into the 14th Amendment. After 1961, the most important provisions of the Bill of Rights were incorporated and applied to the states. Only the Third and Seventh Amendments remain unincorporated. Selective incorporation is the most significant constitutional development that has occurred since the Constitution was written. It profoundly altered the relationship between the national government and the states by giving greater power to the federal government. Selective incorporation has made the federal courts the most important protectors of our liberties, not the individual states. The First Amendment, freedom of religion. The First Amendment guarantees religious freedom in the Establishment and Free Exercise clauses. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. There are, however, different interpretations of the Establishment Clause. One interpretation is that the Establishment Clause prevents the establishment of an official church. This interpretation reflects the views of many of the First Amendment's authors. Another interpretation is that the government cannot favor one religion over another. The government is still allowed to provide funds to religious institutions, but cannot show favoritism. Some argue that there must be a wall of separation between church and state. This is a metaphor first used by Thomas Jefferson in a letter to a group of Baptists in Danbury, Connecticut. In the case Everson versus the Board of Education in 1947, the court applied the First Amendment's Establishment Clause to the states. In doing so, the Supreme Court relied on Jefferson's metaphor in announcing a strict standard of separation between church and state. Justice Hugo L. Black concluded his opinion for the court's majority with the pronouncement that the First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. Ever since Everson, there's been an ongoing debate not only over how strictly to apply the wall of separation in particular cases, but whether the metaphor accurately reflects the meaning of the religious clauses. The lemon test. Funding of religious schools was again a controversial item on the Supreme Court's docket until the Lemon versus Kurtzman 1971 case was decided. This case established the lemon test that government action towards religion is permissible if it is secular in purpose, its effect is not to inhibit or to advance religion, and it does not entangle government and religious institutions in one another's affairs. The lemon test is difficult, if not impossible, to pass. The court hasn't always applied that test consistently in Establishment Clause cases. On religious monument cases on public land, four current justices have all argued for not using the lemon test. Clarence Thomas encouraged the court to just scrap lemon entirely. It's too confusing and has no basis in the original understanding of the Constitution. Neil Gorsuch also agreed lemon should be scrapped because it implicitly endorses the idea that someone should have standing in court to sue over a religious symbol on public land just because they're personally offended by it. There has been multiple cases chipping away at the wall of separation and undermining the lemon test. Van Orden versus Perry in 2005 case ruled in favor of a display of the Ten Commandments outside the Texas state capitol. But in McCreary County versus American Civil Liberties Union of Kentucky in 2005, the court ruled that the display of the Ten Commandments inside two Kentucky courthouses was unconstitutional. In Shurtleff versus the City of Boston in 2022, the Supreme Court ruled that Boston city officials could not bar the display of a flag bearing a Christian message in a square that for decades had welcomed the flags of a wide spectrum of causes, movements, and organizations. The justices laid the groundwork for reversing the lemon test, and all the cases that relied on the test no longer represent sound precedents. The Free Exercise Clause. This protects the right to practice the religion one chooses or protects the right to be a non believer. This clause affirms that no government can compel us to accept any creed or to deny us any right because of what we do or do not believe. The Supreme Court has been consistent and strict in protecting free exercise. In West Virginia State Board of Education versus Barnett in 1943, the court upheld the rights of children of Jehovah Witness family to refuse to salute and pledge allegiance to the flag on grounds that their religious faith did not permit it. People their religious beliefs, but that right is not absolute. The difficulty is distinguishing between religious beliefs and actions. In the case Employment Division versus Smith in 1990, there was a religious claim by two Native Americans who had been fired from their jobs for ingesting peyote. The court determined that the government does not always need to show a compelling interest if its laws infringe on religious exercise. The Free Exercise Clause also prohibits religious discrimination by public or private entities. In Holt versus Hobbs, 2015, the court ruled that a prison policy prohibiting beards infringed on the ability of prisoners to worship as they pleased. And in Burwell versus Hobby Lobby stores in 2014, the court ruled that the owners did not have to provide female contraceptive coverage due to their religious beliefs. Free speech. There's a general acceptance that the government should not punish a person for beliefs or interfere in any way with freedom of conscience. However, governments may restrain actions associated with beliefs. These restraints are founded on the idea that your right to swing your fist ends where my nose begins. Speech stands between belief and action. It is not an absolute right, like belief, but it is not as easily restricted as is action. Political speech is strongly protected by strict scrutiny and legal standards. The state must establish compelling reasons for limitations on political speech. This includes actions of expressing political ideas, such as political contributions or protest. Political speech is protected unless it leads to immediate harm. Different kinds of speech are subject to different levels of protection, and there is no one single test that is applied to speech cases. In the Federal Election Commission versus Wisconsin Right to Life in 2003 case, the court ruled that political advocacy groups issue ads were protected speech as long as the ads focused on the issues and not appeals to vote for or against a candidate. The case Citizen United versus the Federal Election Commission in 2010 reaffirmed that political speech, such as that made possible through campaign expenditures, is essential to democracy and is protected by the First Amendment. Such speech is not given less protection because it is paid for by a corporation or a union rather than an individual. Laws that regulate some kinds of speech but not others, or that regulate speech expressing some views but not others, are likely to be struck down. Political speech has been consistently protected by the courts even when it is deemed insulting or outrageous. The court holds that all speech is protected unless it falls into one of three narrow categories: libel, obscenity, or fighting words. How we prove libel, how we define obscenity, and how we determine which words are fighting words remain hotly contested issues. Problems arise in distinguishing between words that do or do not fit into the category of unprotected speech. Speech is protected until it moves from the symbolic realm to a direct incitement of damaging conduct or the use of fighting words. An example of unprotected speech would be expressive speech that directly incites physical conflict with the use of so called fighting words. Fighting words are speech that, when directed at a person, the speaker should reasonably understand is likely to result in violence. Hate speech is speech that, when directed at an individual, their very utterance may inflict injury or tend to incite an immediate breach of the peace. That the words are abusive, offensive, and insulting, or that they create anger, alarm, or resentment is not sufficient reason to ban them or to punish the speaker. The court has struck down statutes criminalizing fighting words or hate speech due to vagueness. However, when the words leave the realm of thought and move into direct and immediate action, their speaker can be held accountable. In the case Brandenburg versus Ohio in 1969, a Ku Klux Klan member, Clarence Brandenburg's conviction on criminal syndicalism charges based on a speech that recommended overthrowing the federal government was overturned. Writing for the unanimous court, Justice William Brennan argued that the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. In the case RAV versus the City of St. Paul in 1992, a St. Paul, Minnesota teen burned a cross on the lawn of an African American couple and was arrested and charged under the city's bias motivated crime ordinance, which bans symbols that arouse anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. In a unanimous ruling written by Justice Anton Scalia, the court held that the ordinance was excessively broad and overruled the conviction. In the case Snyder versus Phelps in 2011, the Reverend Fred Phelps of the Kansas based Westboro Baptist Church and his followers came to national prominence in 1998 by picketing the funeral of Matthew Shepard, and later they began demonstrating at military funerals using incendiary rhetoric. In 2006, members of the church demonstrated at the funeral of Lance Corporal Matthew Snyder, who was killed in Iraq, and were sued by his family. In an 8-1 ruling, the U.S. Supreme Court upheld Westboro's right to picket. Chief Justice John Roberts' ruling rested on existing U.S. hate speech precedent. Simply put, the church members had a right to be where they were. Protests such as the one above leads to speech plus, which is speech along with a physical activity such as picketing or forms of peaceful demonstration or assembly. It is conditionally protected. Restrictions imposed on it by state or local authorities are acceptable if properly balanced by public order considerations. Also, with speech plus comes symbolic speech. These are actions meant to send a political message and, as such, are protected, such as flag burning. Student free speech. Students have First Amendment rights in school because you do not lose your right to free speech just by walking into a school. You have the right to speak out, hand out flyers and petitions, and wear expressive clothing in school as long as you don't disrupt the functioning of the school or violate the school's content neutral policies. These rights in school are not absolute. Schools can regulate speech for two reasons. First, schools can impose reasonable rules to regulate the time, place, and manner of expression. For example, a school can have a rule that you can't circulate a petition during class time. These rules exist to prevent disruption to your education, and what counts as disruptive will vary. Second, schools can impose content neutral rules, limiting certain categories of speech when they have a good pedagogical reason to do so. Content neutral policies are rules that have nothing to do with the message you're expressing, but restrict an entire category or action. For example, a school can prohibit students from wearing any shirts with text on them because the rule applies uniformly regardless of what someone's shirt says. A school can't restrict the message of your speech unless your speech falls into certain categories, such as if it's lewd or offensive, causes substantial disruption, or promotes drug abuse. In the case Morse versus Frederick in 2007, the court ruled a school could suspend a student, Joseph Frederick, for displaying a banner that reads, "Bong hits for Jesus." Freedom of the press. The freedom of the press is critical to a democracy in which the government is accountable to the people. A free media functions as a watchdog that can investigate and report on government wrongdoing. The media are sometimes called the fourth estate or the fourth branch of government. This designation reflects the unofficial but widely accepted role the news media plays in providing citizens with information they can use to check government power. Information supplied by journalists helps citizens make informed decisions on a host of issues from local school funding to food and drug safety, and of course, which candidate to vote for. Only through free and uncensored expression of opinion can government be kept responsive to the electorate. Hence, the First Amendment states Congress shall make no law abridging the freedom of speech or of the press. In a series of court cases, the Supreme Court has sought to protect the freedom of the press. In Gitlow versus New York in 1925, the court applied free speech and press protection to the states through the Due Process Clause of the 14th Amendment. In Neer versus Minnesota in 1931, the court fashioned the First Amendment doctrine opposing prior restraint and reaffirmed that the incorporation of the First Amendment. Prior restraint is an effort by the government to block publication it deems libelous or harmful in some way. The New York Times Company versus United States in 1971, also called the Pentagon Papers case, the Supreme Court defended the First Amendment right of free press against prior restraint by the government. The courts have never interpreted the First Amendment in absolute terms. Like almost all rights, the freedom of speech and the press are limited. The courts have not recognized additional protections allowing journalists to withhold information from grand juries or legislative investigating committees. Reporters don't have a constitutional right to ignore legal requests. Press sources are also not guaranteed protection either. Governments may also seek to prosecute individuals who leak information to the press, such as Private First Class Chelsea Manning and Edward Snowden. Some speech is not protected at all, which includes statements made in reckless disregard of the truth that are damaging to the victim. When written, it is libel. When spoken, it is slander. It is extremely difficult for public figures to win a libel suit against the media. In the New York Times versus Sullivan in 1964, the U.S. Supreme Court ruled that to hold a defendant liable for defaming a public figure, a plaintiff must prove that the defendant acted with actual malice. The actual malice rule makes the speaker's state of mind the constitutional hurdle in any defamation case brought by a public figure. The rights of assembly and petition. The right of the people to peacefully assemble and to petition the government for redress of grievances protects two distinct rights: assembly and petition. While neither assembly nor petition is synonymous with speech, the modern Supreme Court treats both as subsumed within an expansive speech right, often called freedom of expression. The right to assemble has been a crucial legal and cultural protection for dissenting groups and unorthodox groups. The suffragists, abolitionists, religious organizations, labor activists, and civil rights groups have all invoked the right to assemble in protest against prevailing norms. When the Supreme Court extended the right of assembly beyond the federal government to the states in its unanimous 1937 decision, DeJong versus Oregon, it recognized that the right of peaceable assembly is a right similar to those of free speech and free press and is equally fundamental. There are conditional restrictions on the freedom of assembly. The Constitution does not give people the right to communicate their views to everyone, in every place, at every time that they wish. Governments may not censor what can be said, but they can make reasonable time, place, and manner regulations for protest or parades. Last but not least, civil disobedience, even if it's peaceful, is not a protected right as the First Amendment protects peaceful, not violent assembly. The right to petition the government for redress of grievances is among the oldest in our legal heritage, dating back 800 years to the Magna Carta and receiving explicit protection in the English Bill of Rights in 1689, long before the American Revolution. The right to petition plays an important role in American history. The Declaration of Independence justified the American Revolution by noting that King George III had repeatedly ignored petitions for redress of the colonists' grievances. Today, the right to petition is best represented by lobbying. While the First Amendment protects the right to petition, the Supreme Court has determined that Congress may regulate individuals who are paid to lobby Congress. Obscenity and pornography. Pornography and obscenity are difficult to define and thus difficult to regulate. Justice William Brennan provided a definition of obscenity that is speech or writing that appeals to prurient interest and is without redeeming social importance. Prurient is defined as marked by or arousing an immoderate or unwholesome interest or desire, especially arousing or appealing to sexual desire. This definition actually caused more confusion. In 1964, Justice Potter Stewart wrote that pornography was impossible to define, but added, I'll know it when I see it. The Supreme Court later tried to define pornography as a work that, as a whole, is deemed prurient by the average person according to community standards, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. However, in a series of cases, the court is often sided with free expression. In Reno versus American Civil Liberties Union 1997, the court struck down the Communications Decency Act, which sought to regulate online transmission of obscene material. And in the United States versus Playboy Entertainment Group in 2000, the court struck down a federal law requiring cable TV companies to limit sexually explicit programming to late night hours. The Second Amendment. The Second Amendment reads a well regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Such language has created considerable debate regarding the amendment's intended scope. On the one hand, some believe that the amendment's phrase, the right of the people to keep and bear arms, creates an individual constitutional right to possess firearms. Under this individual right theory, the Constitution restricts legislative bodies from prohibiting firearm possession or renders prohibitory and restrictive regulation presumptively unconstitutional. On the other hand, some scholars point to the prefatory language, a well regulated militia, to argue that the framers intended only to restrict Congress from legislating away a state's right to self defense. Scholars call this theory the collective rights theory and assert that citizens do not have an individual right to possess guns and that local, state, and federal legislative bodies therefore possess the authority to regulate firearms without implicating a constitutional right. In 1939, the Supreme Court in United States versus Miller adopted a collective rights approach, determining that Congress could regulate firearms and that the framers included the Second Amendment to ensure the effectiveness of the military. This precedent stood for nearly 70 years until 2008 when the United States Supreme Court revisited the issue in the case of District of Columbia versus Heller, where, in a 5-4 decision, the court struck down the D.C. handgun ban as violative of that right. The court proclaimed that the Second Amendment established an individual right for U.S. citizens to possess firearms. While firearms can be regulated, they cannot be banned. In 2010, the court further strengthened the Second Amendment protections in McDonald versus the City of Chicago by finding that the amendment applies to the states through the incorporation doctrine. The strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves against tyranny and government. Thomas Jefferson. Firearms stand next in importance to the Constitution itself. They are the American people's liberty teeth and keystone under independence. George Washington. To disarm the people is the best and most effectual way to enslave them. George Mason, co author of the Second Amendment. Fourth, Fifth, Sixth, and Eighth Amendments. Rights of the criminally accused. The Fourth, Fifth, Sixth, and Eighth Amendments taken together are the essence of due process of law. The due process of law refers to the right of every citizen to be free of arbitrary action by national or state governments. Due process is the rules and regulations that restrain those in government who exercise power. The procedural due process refers not to the law itself, but how a law is applied. Originally, it was limited to criminal prosecutions, but it now applies to most kinds of governmental proceedings. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or the things to be seized. This right guarantees the security of citizens against unreasonable or improper searches and seizures. In Mapp versus Ohio in 1961, the court then ruled that all evidence obtained by searches and seizures in violation of the Constitution is, by that same authority, inadmissible in a state court. This case established the exclusionary rule, which is the ability of courts to exclude illegally obtained evidence. This exclusionary rule was adopted to eliminate any incentive for police misconduct. There are exceptions, though. Police who relied in good faith on a search warrant that subsequently turned out to be defective or granted improperly, and that police could conduct searches using anticipatory warrants. Changes in technology have impacted the jurisprudence of the Fourth Amendment. In Riley versus California in 2014, Riley was stopped by the police for driving with expired tags. During this traffic stop, officers found a cell phone and searched it, finding videos and photos that linked him to a previous crime. The Supreme Court ruled that the government needs a warrant based on probable cause to search a cell phone. In the case Carpenter versus the United States in 2018, the police arrested four men in connection with a series of armed robberies. The government was able to obtain without a warrant the location records for each of the phone numbers of the men connected with the robberies. With this data, the government was able to see the approximate location where these suspects had been and were able to link them with the robberies. In a 5-4 decision, the Supreme Court held that obtaining the cell site location data violated one's legitimate expectation of privacy in the record of his physical movements that were tied to the cell phone's location data. Traditionally, the Fourth Amendment has been interpreted to say that individuals lack any protected interest in records that are possessed, owned, and controlled only by a third party or by what a person knowingly exposes to the public. However, the extension of the Fourth Amendment to our cell phones or information that we store online has the potential to be violated, abused, and searched differently than traditional types of Fourth Amendment searches. Cell phone usage has made it increasingly harder to control what a person knowingly exposes to a third party, and even harder to know if these protections against searches and seizures extend to our cell phones. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. A grand jury determines whether there is sufficient evidence available to justify a trial. The grand jury acts as a check on the government's power to prosecute, providing a body of citizens to review the case. The protection against double jeopardy, or being charged twice for the same crime, does not prevent punishment by the national and the state governments for laws pertaining to the same offense. It also doesn't apply to successive prosecutions for the same crime by two states, nor does the double jeopardy clause forbid a civil suit. The right to remain silent means that persons cannot be compelled to testify against themselves in criminal prosecutions. Protection against self incrimination is designed to strengthen the fundamental principle that no person has an obligation to prove innocence. The burden is on the government to prove guilt. In Miranda versus Arizona, 1966, The court announced that no conviction could stand if evidence introduced at the trial had been obtained by the police during custodial interrogation, unless the suspects were notified that they have a right to remain silent and that anything they say can and will be used against them. It also stated that the suspect has a right to terminate questioning at any point and to have an attorney present during questioning by police. The right to have a lawyer appointed to represent them if they cannot afford to hire their own attorney will be discussed later. Eminent domain. The Constitution has a variety of clauses protecting property rights, particularly the Fifth Amendment's Takings Clause. Eminent domain is the power to take private property for public use, but the owner must be fairly compensated. In Kelo versus the City of New London in 2005, the Supreme Court upheld the government's power of eminent domain for the purpose of advancing the economic development of a community. However, just compensation is not always easy to define. An owner is not entitled to compensation for the personal value, just the actual market value. The government may, however, impose land use environmental regulations, temporarily prohibiting the development of a property without compensating the owners. This is a regulatory taking. The regulation has effectively taken the land by restricting its use. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Sixth Amendment is meant to protect the rights of citizens during criminal trials by establishing fair trial procedures. The Constitution guarantees a speedy and public trial and an impartial jury, but it does not define speedy or impartial jury. The Constitution guarantees the accused the right to be informed of the nature and cause of the accusation so that he or she can prepare a defense. The defendant has a right to obtain witnesses in his or her favor and to have the judge subpoena or order witnesses to appear at the trial and testify. All persons accused of crimes will have the right to representation by counsel throughout each stage of the criminal process and to a fair trial by an impartial jury. The right to a court appointed counsel was established in Gideon versus Wainwright in 1963. The court ruled that because of the complexities of the legal system and the potential for being deprived of one's basic liberty, the government must provide an attorney to a criminal defendant who cannot afford one. Eighth Amendment. The Eighth Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. The prohibition of cruel and unusual punishment has never been interpreted by a majority of the Supreme Court to bar the death penalty. In the early 1970s, the court ruled that the mechanisms by which most states meted out the death penalty failed to meet the standards required by the Eighth Amendment. In response to the court's ruling, states modified their capital systems, and since capital punishment was reinstated in 1976, nearly 1,500 people have been executed nationwide. More than 2,700 are on death row right now. Problems with the death penalty is that there is ample evidence of racial bias in applying the death penalty. Plus, DNA tests have established the innocence of a sizable number of those convicted of murder. Since 1973, 164 people who were convicted of murder and sentenced to death have been exonerated. Cruel and unusual punishment goes beyond the death penalty. Overcrowding and other dangerous conditions in prisons, such as inadequate food, medical care, and sanitation, may violate the Eighth Amendment. The prohibition against excessive bail or fines is largely moot because excessive is not defined. The right to privacy. Neither the Constitution nor the Bill of Rights mentions the right to privacy. This right was established in Griswold versus Connecticut in 1965, where the court interpreted elements of the First, Third, Fourth, Fifth, Ninth, and 14th Amendments and ruled that the right to privacy was implied by the above amendments. This right has three aspects: the right to be free from government surveillance and intrusion, especially with respect to intimate decisions on sexuality; the right not to have the government make private affairs public; and the right to be free in thought and belief from governmental regulations. In Roe v. Wade, 1973, the Supreme Court ruled that the right to privacy extended to a woman's decision, in consultation with her physician, to terminate her pregnancy. The ruling in Dobbs v. Jackson Women's Health Organization in 2022 overturned Roe and stated that the Constitution does not confer a right to abortion and largely left the matter to the states. The end.